us here today. And we have two speakers on tap to talk about both Koby Francis, and we have someone to talk about specifically the jury. So if I could ask you, Fawn, to introduce yourself. Fawn Walker Montgomery is from Take Action Advocacy Group, and I would ask that you introduce yourself now.
Hello, everyone. My name is Fawn Walker Montgomery. I am the CEO and co-founder for Take Action Advocacy Group. I am a Black female. I have braids in my hair. I have glasses on, a red lipstick, and blue and black earrings with Angela Davis on the label. So that's my visual description. Thank you so much for having me here today. Should I just kind of go on into it, Autumn?
Yeah, well, we're going to have Will Snowden introduce himself first, and then we'll proceed.
My name is Will Snowden. I am the founder of the Juror Project. I'm what folks would call a light-skinned Black man with a medium-sized beard. I'm wearing a black t-shirt with the word juror on it in red. And really excited to be here with you all. Thank you.
Thank you. I'm really excited to have you both here to talk about these issues today, and I should go ahead and describe myself. I'm a dark-skinned Black woman with tight, smaller locks in a ponytail. Behind me is a white wall. I'm wearing red glasses, red framed glasses, and gold hooped earrings. And I'm excited to be on this call today. So, Fawn, if you could go ahead and give us the background on the case of Koby Francis, or say what you think it is that we really need to know or be updated about him and his situation, I would appreciate that.
Yeah. So when I tell the story, I like to tell it in several different parts. I like to tell how it started, what began and how it ended, because it really was a time of community trauma for my community of McKeesport. So this also placed in McKeesport, Pennsylvania. My organization primarily focuses on those small areas outside the bigger cities, such as the Mon Valley. So this is an area of McKeesport that I was born and raised in, so I've lived there my entire life. I know Koby, I know Koby's family. Koby went to an after-school program with my daughter for years, so I'm very familiar with the family. I know Koby to be a well-behaved young man. I've spoken with him since then. I know he is remorseful about what occurred and how everything went down. So like I said, when I tell the story, I like to start with giving those details about Koby and his family and their ties to the community, because a lot of times when these things happen, we get villainized in the process. So I always want to start with the fact that, I know the family. I know Koby. I've known him since he was little, and even, through his development. So this whole thing started, there was a PFA against Koby, and he was in Crawford Village. Now the PFA was for Norfolk Sales, not Crawford Village at McKeesport. So the person who was aware of the PFA said they seen him down there. So they called the police, and the police arrived. They said, "You're in violation of the PFA." And Koby said, "I'm not, because I'm in Crawford, not Norfolk Sales." So an argument ensued, and they decided to arrest Koby. They claimed they searched him. And then when they got in the car, we don't know what happened, what was said to Koby. But when they got out the car, there's video of Koby having a gun from somewhere and kind of shooting the officer in the stomach. But no one knows where the gun came from. They clearly didn't do a good search on him at all. So all of this is on video. Koby runs. I get a call 20 minutes later after all this happened. So I start to ride around my city to make sure that the Black people are safe. Oh, yes, absolutely. So as as I'm riding around the city, that's where I was getting into Autumn. I see over 15 police departments in my community. They are knocking on doors. They have dogs out. They are, sniffing everywhere. And then I start to get calls that they are forcing their way into people's houses at gunpoint, looking for Koby. People who've never heard of Koby don't know of the situation. They block people from leaving and coming into the city. If you were leaving out of the city, they were searching your trunk without permission. This went on all night. So we were in rapid response mode. We're running around making sure that they don't kill anybody. We're calling lawyers, getting the ACLU on the phone. So this went on for a couple days, actually. And then we had to really forcefully advocate for them to stop, as well as for Koby to be found alive. Because as we all know, when these things happen with white victims, they're found and they're brought in alive. So we demanded he be brought in alive. And he was. They actually located him alive. And we've been working with him ever since and kind of referred him to ALC. So the case is so layered because of the effects and the community trauma that occurred to us that night. It went on for the next 5 days. They kept going up in people's houses, especially Koby's family. They would pull his brother in and out of cars. They were walking into his mother's house, not even asking, just kind of storming themselves in people's houses. So when they did obtain Koby, they're looking at mandatory sentences, which is, as we know, as abolitionists, none of this is going to work. So that's why we wanted to get together and let people know the trial is coming up and they're looking at giving him a mandatory sentence. And we know the detrimental effects that has on our people. So we wanted to come and let people know that we're looking for court support. When the trial starts on May 30th, we'll be doing an event next Saturday at Crawford Village in McKeesport in the rec center about knowing your rights and really drawing some highlights onto what the community went through that night and what Koby and his family went through and what, we all kind of continue to go through. So that's next Saturday in Crawford Village. And we'll really be highlighting the illegal search and seizures that we went through. It was really traumatic and it really felt like we were under siege. And the amount of resources that the police wasted that night, I work with families who would give the right arm to have that to get some of their homicides solved. The amount of resources that were wasted for one officer being shot does not erase our constitutional rights. One officer being shot should not cause all this. People in my community in McKeesport are shot every day. And this amount of tension I've never seen. So I thank you all for, giving me the opportunity to share the story. Is there anything else that you wanted me to kind of highlight, Autumn?
At this time, but I'm hoping that you could stay around for questions towards the end. I see Miss Kim that you've hopped on, and Kim, of course, is Koby Francis's mother. Really appreciate you both being here, doing this for your son. Appreciate your work in Mon Valley and across really the area, the entire community. I agree with you that we need to be equipped to make sure that we're taking advantage of and are aware of our constitutional rights. So now we should probably jump into the conversation about the jury and about jury power. So I have a list of questions that I'm going to be posing to Will. And if anybody wants to add to these questions, please put them in a chat or raise your hand. I'll be putting the questions, or me or Chris will be putting the questions in the chat. So didn't mean to distract you earlier, Fawn. That's all I was trying to do, was just to post the question there so that everybody could see what we're talking about in case people are coming in or just wanted to reflect. So the first question is, what is a jury? And is there any significance to the number of jurors that are called to be on a jury?
So a jury is a kind of microcosm of our communities in the event that they are representing a small portion of people in our communities to sit in judgment of a person who is going to trial. We have juries both in civil cases and in criminal cases, and ultimately the responsibility of a jury in a criminal case is to decide and to vote whether or not the person is guilty or not guilty. In civil cases, a jury's responsibility is really to decide whether or not somebody is civilly liable or if there's an award judgment or something like that. I know today's conversation we're kind of focusing on criminal juries, and so the main thing that we need to keep in mind is for criminal cases, a jury's responsibility is to represent the values and perspectives of the community, but also to decide whether or not a person that is charged with the crime is guilty or not guilty. When it comes to the significance to the number of people on juries, most juries across the country have 12 individuals, well, 12 to 14. You know, if it's a 12-person jury, there might be 14 people on the jury, and the 2 extra individuals are there in case they're called alternates, and they are there in case one of the original 12 are for some reason unable to sit for the duration of the trial. So let's say somebody gets sick. Instead of starting all over, they can just pop in one of the alternate jurors to participate in the deliberation process. The number 12 comes from England. So when juries were first brought to England by William the Conqueror, I think in about 1066, the idea that was introduced was that there were going to be 12 jurors. At the time, back in 1066 in England, the jurors were actually more like witnesses. They were individuals who knew something about the case. But obviously, the juries have evolved to what we have in 2023, where we typically have 12 individuals sitting to hear the case from the prosecution and any defense from the defense attorneys to decide whether or not a person is culpable of a particular crime.
Easy peasy. Thank you. Our website in Allegheny County describes the jury as a fundamental constitutional right. Can you respond to that or expound on that? And tell us also how juries might change from county to county, state to state across the nation.
So I like to call the right to a jury trial the right so nice they named it twice. And what I mean is that the right to a jury trial was actually included in the original Constitution, particularly in Article 3, Section 2. It states that the trial of all crimes, except in cases of impeachment, shall be by jury. So the original Constitution that gets passed, I believe in 1787, already has the right to a jury trial in it. We also see the right to a jury trial in the Sixth Amendment to the Constitution. So, just remember the Constitution was passed in original form, and then there were 10 amendments that were added sometime later. The Sixth Amendment to the Constitution specifically states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury to the state and the district wherein the crime shall have been committed. And so this is where we get to see the reminder and the codification that in the Sixth Amendment, we also see the articulation of an individual's right to a jury trial. And so we have this baked into our United States Constitution, and it's something that is really part of the fabric of our country. As it relates to the Pennsylvania Constitution, the right to a jury trial is also included there. And what we see in terms of the differing elements of juries from state to state, sometimes it just depends on the qualifications. Sometimes the differences also are determined by the size of the jury. Some jurisdictions, depending on the type of charge, let's say it's a lower level felony, might only have a 6-person jury. If it's a more serious felony, they might have a 12-person jury. But from across most jurisdictions, the role of the jury is fairly the same, and that is to listen to the trial, listen to any evidence or testimony that is put in by the prosecution, listen to any evidence or testimony that is put forward by the defense, and essentially listen to all of that information. And at the end, they get to decide through their perspectives of individuals from that community, through their values that they have developed as residents of that community. They get to decide and they get to vote whether or not they believe the person that is accused of a crime is guilty or not guilty.
I wonder about this element of, or this this term or saying that we hear, like a jury of your peers. And as a court watcher, I've seen as many as 3 people out of 12 with 2 alternates be Black or presenting as people of color. Um, in a, I'm thinking specifically about a capital case that I sat in during their jury selection process. And I'm wondering, this case was for 2 defendants who were both Black. And I'm wondering, does the peer issue, the peer idea apply to the defendants, or is it a reflection of the population?
So the right to a jury of your peers, it is supposed to be codified in terms of individuals from your jurisdiction. There isn't a concrete or universal definition of peer, but we can make the argument that if we have, let's say, an Asian person on trial, that person, in the interest of fairness, should have an Asian person on their jury, because there might be some perspectives or experiences that another Asian person could provide insight to in terms of the deliberation of the case. There is no guarantee, or there is no right to have somebody on your jury that holds the same racial identity group as you do. But there's social science and there's social research that really lifts up the benefit of diversity. And so I think we are in a good position to make sound arguments why diversity is something that should be required as it relates to the fairness of our criminal legal system. When it comes to peers, the way in which jurisdictions try to establish a jury of one's peers is by summoning individuals from the jurisdiction where the case is going to trial. And so, as many of you know, the lists that are utilized, I believe, in Allegheny County are voter registration and DMV records. This is a common practice across the country, and I live in New Orleans, Louisiana. I've practiced in New Orleans, Louisiana, and we've done some research on how using those 2 lists of voter registration or DMV records yields a adequate kind of representation of the Orleans Parish community. And what my preliminary research has found, that in New Orleans, when we only use voter registration and DMV records, we effectively exclude about 35% of individuals who otherwise would be eligible to serve on a jury, but since they're not registered to vote, or since they do not have an active driver's license, they simply do not get summoned to a jury, even though they meet the qualifications. And most of the qualifications and jurisdictions require an individual to be a resident of the county where the trial is taking place, be 18 years old, understand the English language, not have any mental incapacities that would prevent them from sitting during the trial. And when we think about those qualifications and when we compare them to the lists that are utilized, they don't quite match. Another qualification that we often see in jurisdictions is not have any felony convictions. I will say across the state, there are 25 states that permanently disenfranchise people with felony convictions from serving on the juries. So that means, in those jurisdictions, people with felony convictions will never serve on a jury. Now, there are jurisdictions around the country that do allow some individuals with felony convictions to serve on a jury, but that really varies on a state-by-state basis. So the question is, can a jury of peers be possible for a Black person if they're going to trial and there aren't any Black people on the jury? This is a question that we've been wrestling with in the law for decades. And this idea of whether or not a trial can be fair isn't solely viewed as it relates to the demographics of the jury. But as we get less and less diversity on the jury, we begin to call into question the level of fairness that an accused person going to trial will experience.
How can it become balanced?
So when I think about what's removing diversity from our juries, there are 4 things that I lift up. 4 main contributing factors for removing diversity from our juries. The first is felony disenfranchisement, and I've already spoken a little bit about the data across the country as it relates to the jurisdictions that permanently disenfranchise people with felony convictions from serving on a jury. So the first kind of category is felony disenfranchisement. And I believe in Allegheny County in Pennsylvania, they do not allow people with felony convictions to serve on a jury. I'll have to double check that, but when I last looked, I believe that was the case. The second contributing factor, removing diversity from our juries, is the summonsing process. So the lists that we are utilizing to summon jurors is removing diversity. And as I was mentioning, when you use voter registration and DMV records, you simply are excluding a lot of people for not being registered to vote or not owning a car. And then we think about in jurisdictions where if you have parking tickets that you haven't paid and your license has expired, if you're in a jurisdiction where the Office of Motor Vehicles or Department of Motor Vehicles is only sending over a list of current and active driver's license holders, then individuals whose licenses may be temporarily suspended may not be included in that list. The third contributing factor is what we call voir dire, which is the legal term that is used to describe the jury selection process. So when jurors are in the room and the case is, really starting jury selection, voir dire is the conversation that takes place between the lawyers and the potential jurors. And so what we end up seeing is certain questions being asked that are sometimes offered or utilized to specifically target certain identity groups, seeking affirmative answers, and then using those affirmative answers to remove folks from the jury. So I'll give an example. When I was a public defender here in New Orleans during voir dire, a lot of times the assistant district attorneys would ask New Orleanians, how many of us have had a bad experience with the New Orleans Police Department? And then there would be some black people on the jury who would raise their hand. They would talk about those bad experiences, and then they would get kicked off. So voir dire and the way that certain questions are asked during the voir dire process is another contributing factor, removing diversity from our juries. And then the fourth contributing factor is community mindset. Really excited to be here with you all today, a group of folks who are interested in learning more about jury service. You all are the exception. Unfortunately, many people, when they get a jury summons in the mail, they think about ways in which they can get out of jury service. They might call somebody in their family network or their friend network who works at the courthouse or who was a lawyer or who was a judge and says, hey, I just got a jury summons. How do I get out of jury service? And so what we really want to do and what the Juror Project focuses on is improving people's perspective of jury duty so that they know when they get that jury summons in the mail, that's access to power. And if we in fact want to improve our criminal legal system, we need to really understand how we, as somebody who might be a DJ, a banker, unemployed, or a teacher, whatever it might be, just because you're not a lawyer doesn't mean you can't improve the fairness of the criminal legal system. And that summons gets you into the courtroom, and that summons gets you power, and that summons gets you an opportunity to increase the overall fairness of the trials that are taking place. So we think about those are the contributing factors. What are the solutions? What can we do about it? Well, with felony disenfranchisement, we can be having conversations about restoring that right to serve on juries for people with felony convictions and the benefit that can have on the diversity of our juries, particularly in jurisdictions where there are predominantly more black people with felony convictions, and those are the individuals being disenfranchised. The second, contributing factor in terms of the summonsing process, thinking about what are the lists that we could utilize to expand beyond just using voter registration and DMV records to get to what they call an 85% capture rate. So the American Bar Association has this standard, says if you want to be doing this right, you should be using lists that capture about 85% of the eligible juror population. So what that means is, sure, you can use voter registration, you can use DMV records, but let's supplement those lists. So let's use utility bills, let's use tax assessor bills, let's use child support payor lists, child support payee lists, whatever it might be to get us to that 85% figure. The third, as it relates to voir dire, is having trainings and conversations with district attorney offices and getting them to commit to not ask questions during the voir dire process that are intentionally discriminatory or intentionally designed to elicit affirmative answers from black people and using those affirmative answers to remove those folks from the juries. So really having conversations with our district attorneys to have commitments to fair and equitable voir dire practices. And then the fourth thing is just really changing our mindsets, that when we have concerns and criticisms about our criminal legal system, really understanding and owning that when we get summoned for jury service, this is an opportunity for us to contribute to the overall fairness of our criminal legal system.
Thank you. Yeah, when I was watching that jury selection process some time ago, it was a capital case, and I remember the question that the prosecution often asked leaned on their sensibilities in terms of spirituality, really, and it went something like, this is a capital case. If the jury finds these people guilty, would you be able to say it's so, knowing that they would be, it was a capital case. And I remember seeing so many people who had an otherwise liberal mindset, and so many people who professed faith being striked from the jury. Um, there's a question in the chat that I did want to say, from coming from Fawn. Is there any state or federal legislation that addresses racism in jury selection?
Yes, so there, in 2018, Washington State introduced some legislation that specifically qualified what were described as presumptively invalid reasons to strike a person from a jury. And so let me give a little context to what that is. So some of us are familiar with this case called Batson versus Kentucky, and it is kind of the flagship case that is often referenced, that has created some protections around preventing juror discrimination. Just as in terms of background, Mr. Batson was charged with theft-related crimes, receiving stolen goods, stuff like that. He's going to trial in Kentucky in 1986. I'm sorry, the case goes to the United States Supreme Court in 1986 because during his trial, the prosecutor had used what are called peremptory strikes to remove the 4 black people from the jury. And the defense attorney objected and said, hey, he's removing all the black people because Mr. Batson is black and he's trying to whitewash the jury. And at the time, there wasn't a test to be applied to really kind of, well, there was a test, but it wasn't that good. So it goes up to the United States Supreme Court, and they create this thing called a Batson test or Batson challenge. And essentially, when one of the parties suspects that juror discrimination is at play, the step one is you raise the objection. So say, Judge, I want to object to the prosecutor striking jurors 3, 7, and 9. They are all Asian Americans. My client is an Asian American person, and I believe they're trying to increase their chances of winning. So step one in the Batson test is raise the objection. Step two, the party that's being challenged, so in this example, the prosecutor, they have to provide their explanation for removing the person from the jury. So say, no, Judge, I'm not racist. The reason why I removed these 3 jurors is because I didn't like that he didn't make eye contact with me, or I didn't like the fact that he was falling asleep, or I didn't like the size of his hoop earrings, right? It can be any ridiculous reason, but step 2 is provide the explanation. And then step 3, the judge has to decide whether or not the explanation that was given was in fact race neutral. So that's the background of the Batson case. Let's say that there's a jurisdiction where a prosecutor says, I struck this person from the jury because they talked about their bad experiences with the Allegheny County Police Department. So if that case were in Washington State, the legislation says it is a presumptively invalid reason to strike a person from the jury by citing their negative contact with the criminal legal system. And so the way that I think that is addressing some of the racism of our criminal legal system, recognizing jurisdictions where black people are having more contact with police officers, that negative contact is no longer allowed to be used as a justification to strike somebody from the jury. In Arizona, and I'm sorry, for context, when you're doing voir dire, each side, the defense and the prosecution, are able to strike people from the jury in one of 2 ways. The first way is you can strike a juror for what is called legal cause. You have an unlimited amount of cause strikes. And you use cause strikes when you have a very kind of specific and articulable reason demonstrating why that person cannot be on the jury. So some examples, let's say a juror says, my mom is scheduled for eye surgery tomorrow. I am the primary caretaker. I have to take her to the surgery, otherwise she's going to miss it. Scheduling conflict, use a cause strike, that's fine. Another example, let's say somebody has a language barrier. Let's say that their first language is not English, and they share that, they are having difficulty understanding the things that are happening in court. And let's say that court doesn't provide interpreters or translators, then you could use a cause strike for that example. Let's say somebody gets up there and says, the criminal legal system is racist. I don't like the way in which police officers treat black people. Since this case involves police officers arresting a young black man, I'm not going to be fair because I don't trust police officers. Prosecutor is going to use a cause strike to remove that person from the jury. So when we use cause strikes, you can kind of point to and name the reason why that person can't be fair and impartial or can't sit on the jury. So in the examples that I've given you, I talked about a conflict with the schedule for a doctor's appointment. I talked about bias towards police officers. And I forgot the third example that I gave, but I hope you guys are kind of getting the drift of cause strikes. For peremptory strikes, which is the other tool, the unique thing about peremptory strikes is that there are a limited amount. Cause strikes, unlimited. Peremptory strikes, they are limited. I didn't look up, and I apologize. I don't know how many peremptory strikes each side gets in Allegheny County, but sometimes it mirrors the size of the jury. So in Louisiana, if you have a 12-person jury, you get 12 peremptory strikes. Peremptory strikes are usually used for strategic reasons. Let's say I am representing somebody that is charged with burglary, and a juror tells me that their home was just burglarized last night. And I asked them, well, since your home was just burglarized last night, do you think you can be fair and impartial in today's case? And they tell me, yeah, I'll be all right. My gut may not necessarily believe them. My gut might think, well, this person has just been victimized. Their home has just been burglarized. And even though they're telling me that they'll be okay, they might hold some grudges in their, in their conscience and take some of those grudges out on my client. So I'm going to strike this person from the jury because I worry how they might see and associate themselves with the alleged victim in the case that I'm on right now. So I would use a peremptory strike. I couldn't use a cause strike because it didn't rise to that level, so I would use a peremptory strike. So peremptory strikes you can use for pretty much any reason that the attorney wants. It is only when one of the sides suspects that the other attorney is using their peremptory strikes for discriminatory reasons that you can activate the Batson test. Historically, juror discrimination has taken place through the use of peremptory strikes. So in Arizona, just 2021, yes, 2023, 2021, they passed legislation that eliminated peremptory strikes altogether. And so neither the prosecutor nor the defense attorney have peremptory strikes. They only have cause strikes. And so those are two examples of how jurisdictions have used legislation to address historical racist practices through the jury selection process to eliminate and reduce some of that racist influence on our juries.
Wow. Good information. Absolutely. When it comes to advising the jury towards the end of the hearing, things seem to get like really secretive. They will close off the door. You're not allowed in while the jury's being charged. You're probably not allowed out either. What what is the intensity of the charging of the jury? Does it change from case to case?
So when a jury is charged, I just want to kind of frame it for everybody. The case, the fact portion of the case has been completed. So the prosecutors has put forth their case, the defense attorney, if they have a case, they have put forward their case, and now the jury is being charged with the responsibility of deliberation to a verdict. And so what deliberation is, it's an opportunity for the jurors to reflect on all the evidence and testimony that they have heard throughout the case and weigh that evidence and testimony against the charges that the accused person is being taken to trial for. The instructions or the jury charge, so sometimes they're called jury instructions, will vary depending on the nature of the case. And so if a person is charged with unauthorized use of a motor vehicle, there might be 3 elements to that charge. One, that the person, or let's say 2 elements. One, that the person was using the car, and 2, that they did not have permission to use that car, right? So a jury is going to listen to all the evidence and facts, and the jury instructions is going to give the elements of the charges. And so it's going to differ from case to case based on the charges so that the jury knows what elements need to have been proven by the assistant district attorney or the county attorney or state's attorney, the prosecutor, because the term sometimes differs from jurisdiction to jurisdiction. Outside of that, other language that is included within jury instructions or during the portion in which a jury is being charged, and I'm kind of using those terms interchangeably because there are written jury instructions. The charging of the jury is essentially reading, the judge reading those instructions to the jury. And so it does a couple of things. It reminds them, the jury, or tells the jury what the elements are of the case, of what the charges are. It instructs them to only take into consideration facts and evidence that were presented during the case. It ensures and reminds them that they cannot take into consideration facts that weren't presented during the case. It also basically charges them to use the deliberation process to ask each other questions and to deliberate, to chew on all the evidence, to digest everything that you've heard so that you ultimately can produce a verdict for that particular trial.
Right. So we've talked about a little bit about jury selection. We talked about what a jury is. And then we talked about the end of the process. What we've all wanted to get to really is that decision-making process. Does a jury have to make a unanimous decision? What happens when it is or when it's not? And finally, what is jury nullification?
So I'm going to answer the unanimous question first, and then I can get to jury nullification. So the concept of a unanimous jury means that all 12 people, let's say it's a 12-person jury, or even if it's a 6-person, let's say all the jurors have to agree on the verdict. That means everybody has to agree that the verdict is guilty, or everybody has to agree that the verdict is not guilty. Let's say we have a 12-person jury, and 11 jurors vote not guilty, and 1 juror votes guilty. We do not have a verdict because that is not a unanimous verdict. So what ends up happening is the jury, 4-person might tell the judge, hey, we are split 11-1. And usually the judge will tell the jurors, go back and continue to work on it. But let's say that they've done that for hours, and let's say that they've been a couple days and they're still stuck 11-1. It is then classified as a hung jury, and that is in the books as a mistrial, meaning that a verdict was not rendered as a result of that trial. So what ends up happening is that person's case is not finished. They have not been found guilty. They have not been found not guilty. And so the jury will go home and the case kind of starts over. The trial would start over if the prosecutor wants to take that person to trial again. Now, in this example, where there were 11 people that voted not guilty and 1 person that voted guilty, it's unlikely that the prosecutor strategically could think that they could win that case because 11 people voted not guilty. So what they might do is either A, dismiss the case, or B, offer a different type of a plea deal if they didn't offer one before. So let's say somebody is charged with armed robbery, and a jury doesn't come back guilty on armed robbery or simple robbery, let's say the prosecutor could offer a charge of theft, which is a lot lower than armed robbery. Basically using the feedback loop of all the not guilty verdicts that came through, or not guilty votes, and basically learning that their case is not as strong as they want it to be. So unanimous verdicts are required in all 50 states. That was not always the case. In Louisiana and in Oregon, we used to have non-unanimous juries. I won't get into the history of it, but the history is rooted in racism and anti-Semitism. Thankfully, we changed our laws in 2018, and so now unanimous juries are required everywhere. So that's unanimity. As it relates to jury nullification, I want to provide a lot of context around jury nullification so that people really understand that jury nullification is probably the most American thing we have in our criminal legal system. And what I mean when I say that is that this country was partially founded on the principle of jury nullification, or with the history of jury nullification, particularly during colonial times, where the founders at the time wanted to resist the rule of English law. So when the King of England was trying to enforce the English law in the 13 colonies and were charging different colonialists with certain crimes, the juries were nullifying because they did not want the application of English law in the colonies. And so what do I mean when I say nullification or nullify? It is a constitutional premise that essentially represents that a person might be factually guilty, but the values of our community do not condone finding that person guilty, or that the behavior that is being criminalized should not be criminalized, or the use of power by the government is an abuse of power. So when we think about jury nullification, I describe it as a check on the government, preventing it from abusing its power, right? We saw this in the colonial times where they thought the King of England was abusing his government power, and so they were voting not guilty in cases where people were actually factually guilty. Let me kind of give you some examples of how we have seen jury nullification in the United States. I'll say in the 21st century, the most common use of jury nullification is on cases where individuals are charged with simple possession of drugs. Over the last 30 years, we have seen a transition in communities' mindset around the criminalization of drug use. There is much more understanding that people with substance use issues are navigating a health problem, not a crime problem. And so when we see people charged with simple possession of heroin, or we see people charged with simple possession of a nickel bag of weed, we are seeing jurisdictions where those cases are going to trial and juries are voting not guilty because they don't believe that this person should be sent to prison for simple possession of drugs. I'll give you an example that I had personally. One of my very first cases as a baby public defender, I was representing somebody with charged with possession of 2 crack rocks and 3 pills that they did not have a prescription for. And as I'm going over voir dire, as I'm asking questions of the jury, an older black man raises his hand. He says, "You know, Mr. Snowden, I can't vote guilty for your client because it sounds like he has a drug problem and he needs help." Now, when he said that, that just warmed my heart, because that's exactly the type of person that we would want on the jury. And then when he said that, there were 4 to 5 black and white New Orleanians who basically agreed that we need to discontinue the criminalization of people with substance use issues. Little did I know that when they made those statements, the prosecutor struck each and every person with a legal cause strike. So then the question becomes, what does nullification look like? Well, there's a time and a place for you to state that sentiment. And it's not during jury selection, it's actually during jury deliberation. So the question then becomes, when you are sitting in a trial and a prosecutor says, and this is likely what they will say, let's say, Mr. Thompson is charged with simple possession of crack cocaine. You will hear through this case that he was trespassing in our local library. The alarm goes off, the local police department responds, he is arrested inside of the library, and as a result of that search, which is all on body camera, you can see the drugs being taken off of Mr. Thompson. If I, prove all of these elements to you, members of the jury, and there's, no question in your mind that Mr. Thompson did in fact possess these drugs, Ms. McGuire, can you vote guilty? Mr. Harris, can you vote guilty? Ms. Redcross, can you vote guilty? And they will call people out. And the people that actually disagree with the criminalization of people with substance use issues, they'll say, no, I can't vote guilty because this person shouldn't go to prison. And they'll say, thank you. Your Honor, this time I move to excuse juror number 7, right? And they'll just go down the line and they'll remove everybody. So then you have to think about how your questions are being utilized, or how your answers are being utilized and used against you to remove your perspective from the jury. And I believe that this is fundamentally contrary to the Sixth Amendment and the progeny of the Sixth Amendment. So there is a case called Taylor versus Louisiana. It's a United States Supreme Court case that establishes the fundamental right to a fair cross-section of your community when you go to trial. And so what I believe that means is that when a person goes to trial, they have the right to a person on their jury that believes in sending people to prison with substance use issues just as much as they have the right to a person on the jury who does not believe in sending people to prison on the jury. So what does that look like in jury selection? Let's say Mr. Browder does not believe in sending people to prison for substance use issues. When a prosecutor asks, can you vote guilty? If you think it is too early for you to tell how you're going to vote, you can simply say, at this point in time, it's hard for me to articulate how I'm going to vote. I need to listen to all the evidence and facts during the case. I appreciate your hypothetical, but I hesitate giving an answer because I don't have enough information. So first, I never want anybody to lie, right? So that's why I'm sharing with you this language that you can utilize that's not going to get you struck from the jury from a cause strike, right? Because remember, they have an unlimited amount of cause strikes. And if everybody on the jury panel says, I can't vote guilty for somebody with simple possession of drugs, they're going to use cause strikes for everybody. But let's say there's 6 peremptory strikes and there's 12 people in this panel, and 6 people say, I don't have enough information. I don't have enough information. I don't have enough information. The prosecutor might still use a peremptory strike against you, but they cannot peremptorily strike all 12 individuals. And so I lift this up for you all to understand the strategy behind jury nullification that we actually have to have conversations about. Because if you describe yourself as an abolitionist, as somebody who does not agree with the current framework of our criminal legal system, I've seen abolitionists on jury panels and they'll say, we need to blow this whole thing up. We need to tear this whole thing down. And the prosecutor says, thank you. I'll now strike juror number 9, right? And you are not being an abolitionist in that moment, right? To be an abolitionist actually means to be part of the process and share all that perspective that you have in the deliberation room. So we can talk about jury nullification, but we can only do so when we're also talking about how to get on the jury so that you can represent your perspective in that jury deliberation room. So I don't want you all to show up to jury service and being very, not political, but being very forthcoming and loud and proud about your concerns and criticisms of law enforcement, of prosecutors, of prisons, of our criminal legal system. Because when you do that, you get kicked off. Save all that information and narrative for the jury deliberation room so that you can actually be having conversations with fellow jurors about your very concerns. And the last thing that I want to share with you all is when it comes to jury nullification, I get criticized for teaching people about jury nullification because they think I'm promoting lawlessness. Right? And that's exactly, Darren, chess versus checkers. I'm not promoting lawlessness. I believe juries are our only continuous feedback loop where we are analyzing the laws of the government and deciding if they are still consistent with the values of the governed, right? So if the laws of our government have criminalized simple possession of drugs, have criminalized mental health, have criminalized substance use issues, right? That's no longer consistent in some of our jurisdictions. So the ways in which we express that inconsistency between the laws of our government and the values of the governed is through the principle of jury nullification. Because guess what? When I was working in the Bronx, at the Bronx Defenders, and there were juries that were always coming back not guilty on simple possession of marijuana cases, the district attorney just said, hey, I'm going to stop enforcing simple possession of marijuana, right? That's the feedback loop in works, in play. And so I share that with you all because we really have to be conscious of not just talking about jury nullification, but also talking about voir dire and the jury selection process if we really want to be working towards creating a criminal justice system that is worthy of its name. Thank you.
Whoa, that was great. Thank you so much for sharing all of this wealth of information and understanding about the jury process, jury selection with us this afternoon. We are going to be able to post this so that everyone who's not here can benefit from this conversation. I hope that people are getting their minds ready to ask great questions while we have Will with us. And I did see a question earlier that was posed to Fawn that I handed over to Fawn, but should we start there with a question towards Fawn? And maybe Youssef, you can unmute yourself and ask your question directly.
Am I waiting until Pawn answers her question? Because I'm sitting here on pins and needles.
No, you're asking your question to Fawn.
I had
Did
a
you have
question. My question was really to Mr. Snowden, wasn't it?
Oh, okay. That might be a new one.
I'm sorry, I wasn't able to follow the chat. Would you mind just sharing saying your question again?
I got a series of questions initially, and I just want to just kind of get it out there and let you respond in kind. First, does the jury ever get a chance to know that it has the power of jury nullification?
During the actual trial, almost every jurisdiction prohibits lawyers from teaching the jury about jury nullification. And so the nonprofit that I have called the Juror Project, we try to educate folks in the community about why it's important to serve on juries, but also to understand the concept of jury nullification. But to directly answer your question, it is often prohibited from being discussed during the actual trial.
I, as the defendant, am I able to inform the jury that they have the power of jury nullification?
You are not. So when I have tried to talk about jury nullification in trials, the judge has stopped me and said, parties you need to approach. And she specifically told me that I cannot talk about jury nullification, and that if I proceed to talk about jury nullification, I could be held in contempt. And so in cases where the defendant or an accused person, wants to talk about jury nullification, traditionally they would do so through the mouthpiece of their lawyer. If they wanted to say something in court, let's say they're representing themselves, the same restrictions would apply.
Now, only reason why I bring that up is I used jury nullification in Allegheny County in 1977, and but I represented myself, and the court was not able to interfere with my ability to advance my defense. Not being an officer of the court's hands was pretty shackled. The district attorney tried to raise it, and the judge admonished her to allow me to continue talking.
Well, I'm really glad to hear that. And I think you raise up an interesting point. In cases where individuals are representing themselves, the rules might be not as clear as they are when applied to lawyers in the case.
That's basically what I had for jury nullification.
Thank you.
I
We
want
have a
to,
question from Christy.
oh, put me in the lineup, Autumn.
You're in.
Okay, so I see Chrissy's question is, what kind of language would you recommend when asking questions about what kinds of activities we participate in, groups belong to? I always err on the side of like honesty, right? But also recognizing that if I am called to jury service and I am asked the question of like, what groups do I belong to? I'm not going to be able to list every group. Like I'm in so many groups. Usually when lawyers are asking that question, they're just trying to get another picture of you to understand some of the things that you might be interested in. Another random interesting thing about jury selection is it's a lot of it, unless you're getting actual statements, a lot of it is just based on stereotypes and judgments. Sometimes I ask people what books they're reading as a lawyer. One that I often like is what organizations do you donate to? And then another one, if you have bumper stickers on your car, what do they say? That sometimes is kind of revealing. I don't necessarily have language to recommend to you to say as it relates to organizations, but I just lift up the fact that it's really hard for anybody to list all the organizations that they're actually a part of.
Thanks a lot.
Now, if they say, Christy, I see that based on our social media research, you are a member of XYZ. Is that true? And if it's true, you should say, yeah. We don't want people to lie.
Yeah, that was sort of another question. But yeah, like, should we go private as soon as we get a summons or something? Sorry.
You should know that when you are summoned for jury service, lawyers will exercise all of the research they can to develop a complete a picture as possible.
Mm-hmm.
And so if you are concerned about ways in which certain affiliations or certain organizations that you are a part of might accurately or inaccurately reflect the values that you want to be taken into consideration, then you should just be mindful of what is going to be shared prior to your jury service.
Thanks. All right, I'll get off stack so Mr. Harris can join.
Thank you for your
Yep.
questions.
Yeah, that was a great question. It answered one of mine too, because I was wondering, did they do research once they got the jury pool? So I thank you for coming too, and thank you for this information. I love the fact that you want us to be transparent. But if they ask us, can we bring a guilty verdict? I mean, I don't think it would be lying to say I can. That don't mean I will, but I can. I have the power to do it, and I have the choice to do it. But is that how they shape the question? Can you, or do they ask you, will you? Or they can't.
It's usually can you return a verdict of guilty? And
Yeah,
I don't disagree with how you're describing what can and cannot happen.
Yeah, because I mean,
I can trip down the stairs right now when I go back downstairs. Is that going to happen? Probably not. You know,
yeah, probably not. Yeah. So can you? That's like an open question, so I can answer that honestly and knowing that I'm not bringing back a guilty verdict. I just wanted to point that out.
Thank you.
I just went back through the chat and I see I did have a question for Ms. Montgomery. That had to do with, were there any consequences for the police misconduct after the Koby Francis situation? And if so, what is the status of any of the consequences?
So no, there were no consequences. We attempted to go to a city council meeting, and because we got 18 complaints that came into us. No one went to the police, they came to us because we were out doing a rapid response. So we took those 18 complaints with 6 residents to the McKeesport City Council meeting, and they locked the door on us. So we had to contact the ACLU, and they filed a lawsuit because we have the Sunshine Law in PA that says that all open meetings had to be done in front of the public. So it's illegal for them to shut us out. So we had to literally take them to court to get access to the meeting. They attempted to use COVID as an excuse, but if you are not having in-person means you have to have online options. So we had all council meetings were paused for an entire month because we sued them. So once we got access to the meetings, we made official complaints to the city council. 5 residents came and made their official complaints. And then we responded immediately after this happened by connecting the residents with mental health resources and attorneys. All those attorneys didn't play out. A lot of politics got involved and people didn't want to, I guess, ruffle feathers. So we contacted the ACLU and we're now working with them to file a lawsuit against the city for their response to how they treated us that night. So that's the status of it presently at this moment. We're working with that. But no, there's been no consequences of yet. Outside of us making noise about it and calling attention to it, no one would really know that it occurred. The damage that was done, like I said, that night, it's hard to even put it into words. Like I said, we had to connect people with therapy, and we also had to help people fix the property that the police damaged when they came into the doors. So that's the status of where we're at now.
And as it pertains to the electoral status, I understand that the chief executive at the time is running for re-election. Is there an effort to hold him accountable through the electoral process?
Yes, so there is an election now where the district attorney is running. So my organization is a 501c3, so we can't endorse any particular candidates. But we've definitely been applying the pressure for people to vote in general, like we do every election. We actually had a candidates forum this time around where we invited the district attorney to come. His opponent came, but he did not show up. And we always have political forums actually during this time of year, and he never shows when we invite him. We have been very public about our dissatisfaction. He's been here for 24 years and things that he has not been able to get done. But we did extend olive branch to him and his opponent when they came around. So the election is actually this Tuesday on May 16th, but he did not show up for that particular race. But we always use, I would say, the power of civic engagement and voting to get people more aware of how there's intersections with all these issues and to get more involved. But thank you for that question.
Yeah, and in conjunction with that, is the mayor also running? Is he not up for re-election as well?
Yes, of McKeesport. Yes, we have an election with McKeesport as well. So the mayor, he's up for re-election as well. He was in office when all of this took place, and people were quiet. People were quiet when our community was under siege. We were advocating. ALC was advocating. ACLU, APA, One Hood. We called in our people, but we didn't hear from a lot of elected officials. It was almost like it should be excused because it was an officer. That's a lot of what I heard. Well, it was an officer, and I don't care who it is. Nobody doesn't erase our constitutional rights. And it's not an excuse to harass Koby or anybody who was associated with Koby just because one officer was shot. But yes, we have that election going on here as well.
Thank you. And Will, you're on stack.
Yeah, Ms. Montgomery, a quick question. When you were sharing about Koby's case, you used an acronym, and I think it was either FPA or AFP or PAF. I'm not familiar with that acronym. Could you mind telling me what that is?
That's a PFA, is a protection from abuse order.
Okay, thank you.
Mm-hmm.
Thank you. Thank you. It's been an hour, folks. Time flies. I feel like we're really getting hot here. Like there's so much good information in this space. I'm so glad it's being recorded so that we can run it back and learn more. I'm looking forward to being in contact with you, Will, and you coming to talk to us more specifically about how we could be trained to share a lot of this information. And Darren, I so appreciate you putting us in touch with Will in the first place. Darren is from our National Court Watch hub. And I would love it, actually, Darren, if you could close us out with any last words or strong sentiments or just inspirational direction. Anything that you might want to add that may not have been said? If he's still in the call, is he still in the call?
I'm here. No, Will Snowden is phenomenal. I've been knowing Will for years. I've witnessed his trials and sat through many of them. But I would also say, I don't know if Allegheny County allows you to volunteer for jurors, but that may be an option. I know in New Orleans, there isn't a law saying you can't. Well, Louisiana, I should say, there isn't a law that you can't. So we're actively asking people to volunteer and try to get on the jury that way. But I think that's one of the things you should do in your county or in your state, actually, is research the law to see if you can volunteer. I know I was on my last trial or jury duty that I was on was in 2010, and I have yet to be called again. You know, I have never been called again. Although one of the trials ended in an acquittal, where I was an alternate. The other one was a guilty plea, where we broke for lunch and came back and he pled guilty. And so I haven't been called since then. And like Will said, to me, I'm in court I'm in court at least 4 times a month, sitting and watching. That's another avenue that you can do, is understanding that process, so that it isn't something that's a vague concept to you when you do walk in there and go to jury duty. Will Snowden has a great training. If you can get that training down, where he can train you about what you're going to expect going on jury duty. We're doing that here in the city of New Orleans. And so that's another phenomenal thing that can be done for training minorities of what to expect. I think that's what I can leave you with. But yeah, I don't shy away from a jury notice. I love court. I love going to court. I love being a part of the process. And like I tell people all the time, when I was working in the court building, put me out of a job.
Mm-hmm. Exactly. I appreciate you. Appreciate all that you bring to this area of work. I'm so grateful that everybody was able to make it on the call today. I'm super fired up that this is being recorded and going to be available for playing back and learning more. William will continue to be in touch with you so that we can get that formal training, because we could definitely benefit from it. And I do want to look into what it would take to make our county available for volunteerism in terms of jury. It's not that way right now, but I don't know that it's, because of a particular policy or provision or law. So it might be something that we can challenge. We're a Commonwealth, so we are different, but everything can be looked into. Thank you so much, everybody, for coming on the call today. We're going to wrap it up here. And look forward to seeing you on the other side.
Bye.
Thank y'all for coming, everybody.
Good job, Will.
Thank you.
Really appreciate